expeditiously hear the cases brought before it by the respected, learned Justice of the Supreme Court, who until removed was the Chief Justice, Her Ladyship Gertrude Araba Isaba Tokono. Expeditious hearing of this matter and a final determination of this matter will reassure the Ghanaian public that the rule of law works, that we respect the Constitution. Chairman, we submit further that all the delays in the filing of defense in the matter is a strategy to ensure that these cases languish undefended, creating space for this rushed confirmation to proceed unchallenged. Why?
To be off. Yes, Honorable Ayariga, let me hear you.
Why? No,
Chairman. Chairman. I know now and then the minority leader will say that we are politicians and we should be allowed to do politics. Yes, we are politicians and we should be allowed to do politics. But when we sit here, our politics should be guided by rules. The rules are very clear, Chairman. The rules say that where, in the opinion of the Speaker, the words of a member used in a speech are offensive, abusive, insulting, blasphemous, or unbecoming, impute improper motives. Impute improper motives. I repeat again, impute improper motives or impugns the integrity of a member or any other person, the Speaker may order that the member withdraws those words or withdraw and apologize. The Attorney General is a constitutional office created in our Constitution. And he is a member of this House. In the discharge of his functions, you have no right to come and sit here and impute improper motives. Our rules are clear. What you are saying, you are imputing improper motives. Saying that all of it is a charade and then a strategy and etc. to subvert justice. No. Mr. Speaker, how can he say that? I object and I insist that that part of his statement should be expunged. And the rules are very clear that any reference to the conduct of persons mentioned in Rule 7 in any amendment, question, or remarks in a motion or on a debate dealing with any other subject is out of order. And then you, the Speaker, or the 123 Rule 3 says that if you make a determination that indeed he has impugned improper motives, you should order him to have it expunged from the records. And I'm saying that he has impugned, imputed improper motives, and therefore he should expunge that from the records.
Yes, Honorable Minority Leader.
Mr. Chair. Mr. Chair.
Honorable Minority Leader.
I'm a member.
Please put
Mr.
off
Chair.
your microphone. Please put off your microphone. Yes, Honorable Minority Leader. You have the floor.
Seal that to me. But seal that to me.
Mr. Chairman, some of my, yes, sure. I'm saying that my colleague has a point to make. Since a point of order has been raised, I think that it was within every member's right to respond, not limited to only me.
Well, Minority Leader, with all due respect, we are a house governed by rules.
Sure, but
I can be guided by the rules that enable the Speaker or the person presiding to take a point of order against a point of order or a response to a point of order from any other person apart from the person who raised the issue. So the rules are applied. That is why I asked the honorable member to put his microphone off, and then I'm giving you the floor to respond to the issue of the point of order raised. On the response to the point of order being raised. Yes, Honorable Anymedu, let me hear you.
Yeah, Mr. Chairman, I have been quiet since morning, and I think that we must be serious as a committee. Mr. Speaker, I should think that some members of this committee have a preconceived mind, either to object to every word, every letter that is said, and we cannot continue like that. You being the chairman, Mr. Chairman, I pray after the break, Mr. Chair, you have to steer the affairs of this committee. Now, the majority leader, please, I have the floor. The majority leader is not about, but if you are quoting the standing orders, that people are imputing improper motives, you must go to the extent of proving to us that this word is an improper motive. You just don't say it. Now, even the law that you have cited, it's on motions. What motion are we dealing with here? Now, every committee, ever since I became a member of this house, every committee meeting, we start, the chair, the ranking, we come out with preliminary issues before we start the agenda of the meeting. Now, if you raise a question about what I heard other people say that, well, there had been issues, nobody has the right to raise a preliminary issue when the chairman already ruled that he should speak. This is part of us. And if every word is going to be objected to, then I don't think that we are ready for the vetting. Now, we have been here all day. The nominee had not even spoken a word. This objection, that objection, and
Honorable
and yet we are getting nowhere.
Anymedu Entry, you raised a point, but I feel you are out of order. It's not in response to the issue on the floor. So, Honorable Minority Leader.
It's not in response. Wow. Chairman, thank you. Oh, very well. Chairman, nowhere in my submission did I impugn improper motives. Or was there an inference to such an act? Chairman, you must let the majority leader know that he is a majority leader. When you raise your objections and everybody is quiet, and you are so intolerant that you want to find a way to create chaos, I won't give you that.
Leader,
no, Chair, he was just talking.
The chair.
No, but you are closer to him, Chairman. We've all kept our calm. He is showing power, force. I am this, I am that. It's not fair. What he's doing is not fair. It's not fair.
Chairman, what the ranking is doing is not right. You were given 5 minutes. We spent 15 minutes.
You don't have the floor. Honorable Dapamakpo, you don't have the floor. Honorable Roxanne Nelson Dapamakpo, you do not have the floor. You don't have the floor. Please, Minority Leader.
So, Mr. Chair, we've been very calm, quiet, decent. We want to discharge our parliamentary duties, yet the attacks are becoming one too many. Now, let me respond to him. I stated the fact that cases were filed as far back as May. It was only recently that the AG filed a motion for extension of time to file a defense and sought the leave of the court for that. It is a matter in the public domain that long after the time required to file a defense in that important constitutional matter had lapsed, the AG had not filed, the court itself had not issued a hearing notice to compel the AG to come to court until the AG requested, applied to the court for leave to file out of time. It is a statement of fact that we, as the minority, are raising as part of our concerns regarding the constitutional overreach. We are not saying anything less apart from what is in the public domain. So, Mr. Chairman, the majority leader must be restrained. All the confusion is being caused by him. All the confusion, I have my speech before me. I can read it again. You see?
Honorable
Chairman.
Leader,
Chairman.
with all due respect, can you conclude? If I will have to rule on the objection raised, this is what I will say. We have a constitutional mandate to vet the Chief Justice nominee. The issue before the courts, whether a defense has been filed, leave has been sought, defense has not been filed, is a matter entirely in the domain of the courts. And this cannot be a subject matter of discussion at the vetting committee. Consequently, everything said about defense or relating to that is ordered to be expunged from the record. Minority Leader, please proceed.
Chairman with respect. Chairman with respect. Chairman with respect. You are not doing justice. And I say so because everything that is happening here appears to have been well rehearsed by the majority leader with a view.
You see, Honorable Leader,
Chairman,
you have been a majority leader
Chairman,
before.
Chairman.
Becoming a minority leader, there is nothing that is well reserved.
Chairman, this approach where they'll come, force you, speak, put on a mic, then you say it is expunged. What exactly, what particular word are we expunging?
I think you heard my ruling very
Chairman,
loud and clear. If you disagree with it, you know what to do.
Very
Will you
well.
proceed?
Don't worry. Don't worry. We are all aware of what this whole thing is leading to. So no problem. Chairman, we, the minority, hold a view that Article 1271 gives the Chief Justice authority to ensure effective administration of justice. Article 1272 requires all state organs to assist the courts. Yet, in the instant situation, there are no visible steps to compel speedy trial. We have not yet heard of any hearing for all cases challenging the legitimacy of the process leading to the removal of Her Ladyship Justice Araba Isaba Tokono. We believe that the acting Chief Justice wields the administrative power on this matter, and just as the injunction applications were held expeditiously, same could have applied in this instance. Chairman, it is regrettable that our motion that was intended to have dealt upon this matter did not see the light of day. We hold a view that the judiciary is not the executive's enforcement arm. It is neither Parliament's ally in political projects. It is a guardian of our Constitution, the protector of our rights, the final arbiter of all our laws. Its independence is sacrosanct. Its integrity is non-negotiable. It is the oracle of justice emanating from the people of Ghana. Chairman, for all the reasons given, including the very actions of the majority leader, basically denying us every opportunity of expressing our opinion on an important national discourse. Be it known to you, Chairman, and the committee, and the country, that we, the minority caucus, hereby vote en bloc to reject the nominee. We would want to state on record that the majority can proceed with the questions. We do not intend to proceed with any question. We are, however, registering in the strongest terms that we reject the nomination, and the records should reflect that the report of this committee be a majority report.
Woman, comport yourself.
Honorable colleague, when we show you respect, reciprocate. So far, we have extended to you every courtesy. We've heard all those unpalatable words. We've heard the abuse. So please, for posterity's sake, listen to us. We don't need to vet a nominee before we vote against the nominee. We have preliminary issues well grounded in law. You may disagree with us. And we say that on the basis of that, we cannot be part of a process that would give rights to another and deny another of her bona fide as enshrined in the Constitution. Chairman, that said, we would yield to you to proceed whilst we exit this committee room with our views well documented for the records, and on the floor we shall proceed with the debate, further stating our position and take a vote against the nominee as required by the rules of the plenary. Thank you very much indeed.
Thank you very much, Minority Leader. But how do you reject a nominee who is yet to be vetted?
Should I respond?
The report is not ready to be voted for. We are not at a stage of approval. So your conclusion is very preemptive.
No, Chairman, let me
It's
Chairman would respect. Chairman would
this
respect.
is not what I want you to respond to.
No, Chairman,
so
but
I don't want your
Chairman,
response on this.
To the extent that you've raised it, I just need to. I just need to.
Honorable
Chairman,
Minority Leader,
Chairman,
you have your day.
Chairman,
you have your day. The two microphones should be off.
Chairman,
the two microphones should be off. With all due respect,
we have registered our position.
Honorable Minority Leader,
that we have rejected. We don't need to vet
agreed on your position.
We reject it, and we
agreed on your position. Yes. When it is time for voting, then you can vote against the nominee. Yes, yes. So we thank you very much, and we wish you a very good luck. Honourable members.
Why you wishing us a good luck?
Yes, sir. Yeah, okay. Yes. Honourable members, those present here, we have the constitutional quorum to proceed to vet the Chief Justice nominee and present our report accordingly to Parliament. On this note, we will proceed with the vetting questions. And my Lord Chief Justice nominee, members of the committee will then ask you questions, and you are expected to give response to those questions. Be calm and provide answers to these questions. I will start the preliminary questions with you by asking you to tell us briefly about yourself.
Thank you very much, Honorable Chair. Please, before I answer the question, may I be expected to, may I be allowed to read a brief, make a brief opening remarks?
Allowed, you be allowed to do so after you have indicated to us who you are.
My name is Paul Baffoe-Bonnie. I'm a justice of the Supreme Court. I've been a justice of the Supreme Court since 11th of June 2008. So 17 years plus, I've been a Supreme Court judge. Before the 11th of June, for 2 years, I was a justice of the Court of Appeal. Before then, I was 6 years as a High Court judge and 7 years as a Circuit Court judge. I was born on the 26th of December 1956. I went to Korongo Dumasi Secondary School in 1969, finished O-level in 1974 and A-level in 1976. I then proceeded to Legon, where I read BA Law from 1976 to 1979, entered the law school in 1979 and left in 1981. I was called to the bar in 1983, 2 years after I had graduated from the law school, because at the time we were being called to the bar, my colleagues were being called to the bar in 81. I was in Nigeria seeking greener pastures. I taught for 2 years in Nigeria before coming down to Ghana, when I was called to the bar and I started practicing law. As a practitioner for about 5 years in the chambers of Dr. Takiotu in Sekondi, 1 year in Sekondi, and 4 years in Kajetia chambers in Kumasi, where I practiced with my friend the late Sir John, until 1988 when I joined the Ghana Prison Service. I joined the Ghana Prison Service in 1988, and I underwent 6 months military training, and I was posted to Second D. That's where I met my wife. At the time I met my wife, he was also a Bob No rank person. She didn't have any rank, actually. A sixth former who was then starting her career in the prison service. I was with the prison service for 2 years, till 1990, when we were told that I, as a deputy superintendent of prisons, couldn't marry a junior officer because we couldn't go to the mess together. So I opted out of prison service so that she could stay. So I joined the Internal Revenue Service, where I was the legal officer in charge of Eastern and Volta regions, also for 2 years. Then finally joined the bench in 1992 December, and the rest is history. So I was posted to Duyayamkwanta as a second court judge, brought to Kumasi. For 7 years, I was second court judge, and I became high court judge, and then I'm now here. So I've been a Supreme Court judge for the past 17 years, until 22nd of April, when I was nominated to act as the Chief Justice during the period of the turbulence. And I'm here before you as a nominee for the position of Chief Justice. Now, if I may read my opening remarks, now that I've asked the first question.
Thank you very much. So, my Lord, beyond telling us about who you are, you indicated you have an opening remark. We've also seen your credentials. In giving us the opening remark, you should briefly describe the personal values and experiences that you believe most qualify you to serve as Ghana's Chief Justice.
Thank you.
You combine it with your remark.
Okay. Honorable Chairman, it is a profound honor for me to appear before you today as nominee for Chief Justice. The judiciary of Ghana stands at a defining moment. As I appear before you today to be vetted by Parliament, I do so fully aware that this process is not merely a constitutional requirement, it's a national reckoning. My nomination comes at a pivotal moment in Ghana's democratic journey, a moment marked by public skepticism, institutional fatigue, and a growing demand for justice that is not only delivered, but deeply felt. As I step into this role, subject to your endorsement, the nation will look to me not merely to preserve the judiciary's legacy, but to renew it. The nation needs a judiciary that does not merely interpret the law, but elevates the nation's conscience. With your guidance and cooperation and that of all stakeholders, I pledge to restore confidence in our judiciary and leave it stronger than I found it. If I'm endorsed by you, I pledge to lead an era of greater transparency, efficiency, and accessibility in our judiciary. I do so mindful of the constitutional role of the judiciary, not as a political actor, but as a guardian of rights, checks against abuses, and final arbiter in the rule of law. I propose to anchor our transformation on 3 pillars: procedural clarity and predictability, efficiency and accountability, and open justice. If confirmed, I will stand with every judge, every staff, every court user, and every citizen in the belief that access to justice should not depend on who you are or your connections. The Constitution entrusts the Chief Justice not only with judging cases, but with guarding the credibility of justice itself. My task, if confirmed, is to ensure that the law remains both a shield for the weak and a restraint upon the powerful. With your guidance and cooperation, I pledge to restore confidence in our highest institution and leave it stronger than I found it. Now, I am ready for your questions. Throughout my career, from prison service through the Internal Revenue Service and the Judicial Service, where I've been for the past 33 years, I have integrity. I've believed that everything that I have done as a judge has been done with integrity, honesty, and impartiality. I have charted a course of adjudication that believes that the law should be the law for everybody. And that it doesn't matter who you are and what you are. Once it comes to the law, it is no discriminator of persons. That has been my abounding lifestyle. And if anybody were to go through any of my files at any of these places, this is what you come up with: that this man is honest, this man has integrity, and this man has what it takes to be a leader. And I believe that I have what it takes to lead the judicial service.
Thank you very much. That is preliminary. I will then proceed to give the floor to Honorable Roxanne Nelson Kwame Eche Dapamekbo to ask questions. Honorable member, you are entitled to 3 questions. You may ask up to 3 questions.
Chairman, thank you very much. I'm guided. My Lord, you're welcome.
Thank you very much.
I wish you all the best.
Thank you.
And thank you for guiding me at the bar.
You're welcome.
My Lord, you have a very rich CV. But let me touch on a matter that is out there. What would you say to those who suggest that your nomination by the president was a reward for your holding in his favor in the 2013 election petition? It's some debate out there.
Well, I don't know. I don't know where to start from. I actually do not know. I wouldn't know what goes on in the president's mind since I'm not there. But I actually would be disappointed if my only qualification for the Chief Justice nomination is because I voted for the president in 2013. But I mean, that is on a lighter note. But I think I qualify for the position. As I said, I have been a Supreme Court judge for the past 17 years. I would not be presumptuous to say I am the best qualified person in the Supreme Court. No, I would say that. But I've been at the Supreme Court for the past 17 years. The person who has served nearest to me has been there for 10 years, meaning I was at the Supreme Court in 2008. The next person came there in 2015. The others are from 2019 and then 2020. So I think I qualify for the position. And let me add something. I was actually, if you look at my CV and if you follow the trajectory of my career, I was actually admitted, I actually was made a circuit court judge by Chairman Rawlings. Then I was promoted in 2000, and I was sworn in together with Sergeant Jamefe. I was sworn in by the then Vice President, President Mills. Then I was elevated to the Court of Appeal by President Kufuor. Then to the Supreme Court by President Kufuor. So if, that was 2008. So if 17 years later, another president deems it fit to eliminate me to the position of a Chief Justice, I think I cut across all political boundaries. I don't think that, I think I'll be a reason for people to say that, oh, this man is deserving of the position. Because from Rawlings, Mills, Kufuor, and then Mahama, I think I deserve the position, that's why. But as I said, the president might have personal reasons. I don't know that.
Grateful.
Any further question?
Yes, sir.
The Committee of the Judicial Service since 2010. And then I became its chair in 2020. As a part of our engagements last year, we had a lot of stakeholder engagements with IPAC. We had stakeholder engagements with the CDD, CODEO, that is CSOs, and then the Peace Council. The main theme of these meetings was the fact that in 2013, the election petition lasted for almost 8 months. The final decision came on the 29th of August. Essentially, I'm the only surviving member of that panel. Everybody else has retired. The final decision came on the 29th of August. Because Because one of the first drawbacks was we spent almost 1.5 months discussing whether to even allow the NDC as a party to join the action. In the long run, at the end of the day, by a majority of 6-3, NDC was joined to the action. It was one of the greatest mistakes we made in that particular trial. And that was one of the first things we touched on after the trial. We went into a conclave and came up with a decision that, no, there was no need to join any other party. So CI 99 came up, and that was when we decided that the trial and everything could be done within 42 days. So discussions went on, and we agreed on 42 days maximum for presidential election petitions. And so in 2020, when there was an election petition, it was a straight fight between JDM and then Akufo-Addo at the time, and then the EC. And it took 42 days to deal with that election petition. But we know that Kenya does theirs within 21 days. The only time America faced an election petition, that was between Al Gore and Bush in 2000. The election petition, whatever it was, ended with the declaration of the new president before the inauguration. So at most of these forums or fora where we discussed the elections in Ghana, we came to the conclusion that it should be possible to have the election petition concluded before the 7th of January, the inauguration day. And the first suggestion that came, which we think was a masterstroke, was that we should have the elections on the 7th or the 8th of November. If we have the elections on the 7th or the 8th of November, by the 10th, the results would have been declared. If we have the results declared on the 10th of November, we have 20 more days before even November ends. Then 31 days of December, then 6 days of January, making a total of 57 days. Assuming we want to stick to even the 42-day window provided by CI 99, we can have the election petition filed, responded to, and everything tried within the 42 days, because we have 57 days. That is number one. In addition to that, we can have, lawyers say that every originating motion or originating process has to be served personally on the defendant or respondent. But we all know that in this day and age, every form that anybody fills with the EC, you have to provide electronic address. You have to provide email, telephone, WhatsApp, and all that. So instead of saying that you file a petition and it takes 7 days to get to the respondent, using the electronic mail, we can reduce the number of days to, let's say, 3 days. So a process that is filed, if it is served electronically, even the originating process can be filed and served electronically within 3 days. Instead of waiting for, let's say, 1 week for the response, we can reduce the number of days for the response to, let's say, 4 days. So if we adjust times like that, by the time we get to about, let's say, the 30th of November, that is granted that we had the elections on the 7th of November. By the time we get to November ending, processes would have been, pleadings would have closed. CMC, court management conference would have gone through, issues would have been settled, and then the trial will begin. And a trial like that, we can say it should take no more than 2 weeks. And once 2 weeks are there, we say judgment should be given within 1 week on the release of the results. Meanwhile, at this point in time, during December, we have a lot of holidays. But under the fiat of the Chief Justice, the registries can be made to stay open so that processes can be filed, served, exchanged, everything can be done in such a way that we can have all these things done before the end of January, so that by 7th of January, Inauguration Day, we will have our president who will take the sword and swear to his people and be able to say, because we all know in 2013, for 8 months, the president-elect was performing his constitutional duty all right, but he wasn't too sure whether he was going to be chalked off or replaced or what. Even though the 2020 election petition also lasted for only 42 days, it lasted beyond the inauguration. So these are things that we have discussed, and we shall need the input of Parliament when it comes to LIs and CIs to be prepared. So this is what I intend to pursue so that we can have our election petitions, if any, in future. And I'm sure there will be, and before the inauguration day. Thank you, Mr. Chairman.
Thank you very much. Do you have any further question?
Mr. Chairman, thank you. That is so. My Lord, I appear to be the Lone Ranger in this matter. The welfare of the judges at the magisterial level is so dear to me. But I see a disparity in the welfare, in the service of office and conditions of office for what you term professional magistrates, that's lawyer turned magistrates, and the career magistrates. And they do a lot of work, the career magistrates. In some cases, they do relieving in 2 or 3 other district courts within their jurisdiction. So the question is,
yes,
will you consider introducing the career magistrate program to absorb young men who are interested? Yes, reintroduce, because it will be a very heavy source of personnel. And also reforming them in such a way that they will have the opportunity of rising through the ranks to the level. Because recently you just elevated.
Honorable member, I think
finish.
you have
Mr.
asked
Chairman.
your question.
No, Mr. Chairman.
You see, today I said we'll go by the rules. A questioner is not supposed to run commentary. You don't run argument. The foundation cannot be too long. So strictly proceed to ask questions. That is the rule. So Honorable Roxanne Nelson Dapamakwo, ask question.
Chairman, I'm guided. Thank you. So, CJ nominee, will you consider reforming the courses, the career magistrate program in such a way that they will have the opportunity of rising through the ranks and getting to the highest level? Because they do a lot of work as the same as the professional magistrates. Presently, you have about 75 openings at the magisterial level. You just elevated some from the circuit to the high court. Naturally, you will elevate the district judges to the circuit court.
Thank you, Mr. Chairman. In the years gone by, when we started practicing, we had the grade 2 magistrates and the grade 1 magistrates. And the grade 2 magistrates were actually not trained lawyers. Most of them were social welfare workers, retired teachers, and the rest. They were grade 2 magistrates. And then lawyers who joined the bench, but were not 3 years, also had to work as grade 2 magistrates. Her Ladyship, Justice Avril Lovely Johnson, was a grade 2 magistrate in Chebi. I appeared before her when I was a lawyer with IRS in Koforidia. I used to appear before her. So that was, and so, but when lawyers get to 3 years, lawyers who had joined the bench got to 3 years, automatically they became grade 1 magistrates. But with the grade 2 magistrates, the original ones, they never had the chance to go beyond grade 2 magistrate. They couldn't join the bench at any level because they were not lawyers. That was the situation of things until sometime, I think in the 90s, the whole concept of grade 2 magistrate was abolished, leaving only professional magistrates, that's lawyers who were magistrates. But then, around the 2000s, the millennium era, this concept of career magistrate was reintroduced. This time they were not called grade 2 magistrates, but they were called career magistrates. But they were doing the same thing. And this time, the judiciary went one step further. Whilst with the grade 2 magistrates, they were just social welfare persons who had retired or been drafted to become magistrates. With the career magistrates, these were even, they could be even as young as 30 years. In fact, they were the very first ones were actually workers with the judicial service who were drafted to undertake 1 year or 2 year course at the law school. So they took 2 year courses and then they were made career magistrates. But they are not lawyers. So their career path carries them only to the chief magistrate level. And that was it. It doesn't matter how long you stay there, you can get to a chief magistracy, and then that will be the end. But we still maintained the 3 years for professional magistrates. So what then became the order of the day is that these lawyers, these career magistrates, then opted to go and read law. And once they went to read law, then they could transition to become professional magistrates. But here was the problem. You find somebody who has been a career magistrate for, let's say, 7 years, 8 years, 9 years, 10 years. Now he goes to the law school, he transitions to become, he's a lawyer now. And because he hasn't spent 3 years, he has to remain on the career magistrate level until he becomes 3 years. He gets to 3 years. Even though he might be more experienced than somebody who has left the law school and, been practicing for the past 3 years. So there was a problem. And then again, I know, for example, in the army, if you go through the rank of, let's say, the junior ranks, the furthest you can go is maybe chief warrant officer. But in the army, you have a warrant officer who, because of longevity, maybe even be receiving a salary higher than that of a captain at a senior officer level. But with a career magistrate, it doesn't matter how long you stay as a career magistrate. You cannot run an incremental that will make you overtake a professional magistrate, somebody who has joined just this year. All these were problems but as another member was saying, only about a month or so ago, we had a send-off party for a couple of our retired career magistrates. And it was when their CVs, their citations were being read that we realized that we really need them. Because these are the people who are prepared to go to the nooks and crannies of the country. Maybe you are a magician, maybe you have been following the judicial service. But the vacancy at the district court is 116 at the district court. We are not getting lawyers to join at the magistracy, at the district court. Most of them want to come to the circuit court and to the high court. So with the current elevation of some circuit court judges to the high court and the district court to the circuit court, we are going to have an opening for 116. And I can assure you, we are not going to get, no matter how often, how much we advertise, we're not going to get lawyers to come and fill these vacancies. So it is my project that I will be discussing with the Judicial Council, the reintroduction of not only the reintroduction of the career magistrates, but we should be able to have a proper remuneration regime for them so that those who come can stay. And then, again, it should be possible that there should be a law that makes it possible for somebody who has been a career magistrate for a certain number of years, if he becomes a lawyer, then he doesn't need to wait for another 3 years to become a professional magistrate. There should be a smooth transition. This is a project that I intend to pursue.
Thank you very much. I will then proceed to give the floor to Honorable Mahama Shaibu. You are entitled to 3 questions, strictly questions. I can assure you, my Lord, that every member of this committee may want to exhaust the 3 questions. So, strictly questions, no comment. And non-members of the committee, I plead with you to perpetually remain silent.
Chairman, let me thank you very much. My Lord, congratulations. Chairman has cautioned. But, my Lord, cost of litigation
by the day has become very expensive. Legal Aid Commission came in as a stopgap. Unfortunately, they lack the resources to represent clients. So today you have in courts unrepresented litigants. Would you consider fashioning out a very simple procedure which can take care of unrepresented litigants? Thank you.
Thank you very much, Honorable Chair. The legal aid is an orphan. The illegal aid board is an orphan, like the prison service. Now the prison service, they are getting some parents, but the legal aid remains in the doldrums. It is true that cost of litigation is now very high, and it's becoming very, very high. Higher as a result of the delays that are occasioned in the courts, so that even small, minor offenses in the criminal realm, small claims in the civil realm, still have to follow a long queue. So litigation is now very expensive. And when you look at the persons who patronize the legal aid, you realize that, but for the fact that they don't have the means, they wouldn't go there, because they are very much under-resourced. So it is something that I have discussed since I started acting. I have discussed with the Attorney General, and we are trying to find a way of resourcing the legal aid. As a matter of fact, with time, in the long term, we are thinking of even mobile courts, which will be able to take care of some of these things. We are thinking of, I was telling somebody that maybe the president even stole his the 24-hour economy idea from the judicial service, because we have planned for some time now to introduce courts around the clock so that we can have night courts. And then, see, all these are supposed to augment the legal aid situation. If there are courts around to take care of cases, definitely the cost of litigation will go down. So apart from asking for more resources, which I have discussed with the Attorney General, we are thinking so much about other things like having night courts, weekend courts. Already we have weekend courts to take care of electricity and other things. So once we do that, we hope that, and then to cap it all, the ADR, ADR is something, an avenue that we want to highlight. Already we have court-connected ADRs, and then we have set aside weeks, 1 week in every term, to have ADR sensitization. But people are still not sensitized enough to resort to ADR in some of their claims. So we have a combination of plans to get rid of, to restore the legal aid and also reduce the cost of litigation. Thank you.
Thank you very much. I recognize a supplementary question from Honorable Mahama Yarega, the leader of the House. You have the floor.
Thank you. So, my Lord, do you have your commitment that your court will now say 24 hours when you become Chief Justice? Judiciary at 24 hours.
I said we are exploring. Already we have,
we want to pin you down to a specific commitment to this committee that the courts will explore and will sit 24 hours and provide opportunities to citizens to pursue justice 24 hours.
Well, it is possible, but for now, we have some courts that have morning shifts and afternoon shifts. At least for now, we have that one. And we have some courts that sit over the weekends. So it is now left to us to, so we can say we have a 16-hour economy. It's now left to, with time, maybe we will get to a 24-hour. I'm certain the president showed his ideas from us.
Thank you very much. Honorable Shaibu, do you have any further question or follow-up on this question?
Thank you, Chairman. A further question, not a follow-up. Yeah.
That is your question number 2.
My Lord, let's still stay within justice delivery. A very important aspect of how we live. Cases on appeal. Previously, if you're up country, Bolga, Wa, Tamale, you would have to travel to Accra for Court of Appeal cases. I note that there was a system in place that cases were heard in Ho, Kumasi, Tamale, and Cape Coast. This, for some time now, has not been working, or it has been suspended. Would you consider that Accra is not Ghana, and that many regions still will have to travel to Accra to the Court of Appeal? Would you consider reinstating and possibly expanding that service to all regions of this country? Thank you.
Thank you, Mr. Chairman. I think with all due respect to the questioner, I think the question is not factually correct. Yes, we used to have Court of Appeal sitting in certain regional capitals that are not where we don't have them now. But it is not true that all the other regions have been suspended, no. Now we have a Court of Appeal in Accra, as usual. We have a Court of Appeal in Kumasi, where we have accommodation. So they are residents there. The judges, there are 10 judges of the Court of Appeal who are in Kumasi, resident there, dealing with cases in the Ashanti region, Brong-Ahafo, and the north. We have 5 dedicated Court of Appeal judges for Eastern and Volta regions. Dedicated in the sense that they are assigned to only the Court of cases from Eastern and Volta regions. So the Court of Appeal sits in Koforidia. Then a Court of Appeal sits in Sekondi to take care of Central and Western regions, and then the Western North. So we have at least 4 courts of appeal. That is Accra, Kumasi, Koforidua, and Sekondi. These are the 4 places that we have our cases. But whilst because there is accommodation for the judges in Kumasi, they are resident there. The dedicated 5 for Eastern and Volta are living in Accra, but they go to Koforidua 1 week in a month. 1 week in a month. They will go and sit there 1 week in a month. Then those